The moment your bank finds out your spouse has died, the account locks. Not in a few days, not after a review period, immediately. If that account is in your spouse's name only, you will not be able to withdraw a single dollar from it. You will not be able to transfer funds. You will not be able to pay your mortgage, your electric bill, or the funeral home that is waiting for a check. The bank is not being cruel. The bank is following the law. And under that law, a surviving spouse has no more legal authority over a deceased person's sole account than a complete stranger does. Not without a court order. Before we continue, every form, every deadline, every exemption I just walked you through, I've put it all in one place. State by state, form by form, laid out so any senior can find exactly what applies to them in under 5 minutes. It's called the Senior Benefits Playbook. It's in the first pinned comment right below this video. Tap it once, and you'll have everything you need. Now stay right here, because the next section is the one most people miss. Most married couples believe that because they are married, they automatically have access to each other's money. That is not how the banking system works. Marriage does not grant you ownership of your spouse's individually titled accounts. Under state probate law, an account held solely in the deceased person's name becomes part of their estate. The bank freezes the account the moment it receives notification of the death, and no one can access the funds until a probate court appoints an executor and issues a legal document called letters testamentary. In a clean, uncontested case with no complications, that process takes 30 to 90 days. When there are disputes, missing documents, or no will on file, it can stretch to 6 months or longer. During that entire period, the money is untouchable. My name is Thomas. I study the financial and legal rules that affect seniors and retirees, the rules that banks, government agencies, and financial institutions will not explain to you unless you already know to ask. And the single most common financial emergency I see among married seniors is not fraud. It is not identity theft. It is a surviving spouse standing at a bank counter with a death certificate and being told they cannot access their own household money. That is the emergency no one prepares for because no one believes it will happen to them. Let me show you what this looks like. Consider a couple named Gerald and Patricia. Gerald is 73. He managed the household finances for their entire 41-year marriage. The primary checking account, the savings account, and a certificate of deposit, totaling $86,000, are all in Gerald's name. Patricia's name does not appear on any of them. She has a debit card. She has been spending from that checking account for decades. But her name is not on the account title. She is listed as an authorized signer. That is not the same thing as being a joint owner. When Gerald dies of a heart attack on a Tuesday morning, Patricia calls the bank on Wednesday to arrange a transfer for the funeral home. The bank asks for a death certificate. She provides one. The accounts are frozen within the hour. Patricia now has no access to $86,000 of household savings. She cannot pay the mortgage that is due in 9 days. She cannot pay for the funeral. She cannot access the money to hire the attorney she needs to begin probate. She is told that probate, including court fees and attorney costs, will likely run between $1,500 and $7,000. The money to pay for that process is sitting in the frozen account she cannot access. The money is there. It is visible on her statement. She cannot touch it. That is not an unusual case. That is the default outcome when accounts are titled in one spouse's name. The bank is required by law to freeze the account to prevent unauthorized withdrawals and protect the estate from creditor disputes. The bank does not make exceptions for spouses. It does not make exceptions for emergencies. It follows the legal structure of the account title and nothing else. Here's what would have prevented every part of that situation. There are 3 account structures that bypass probate entirely, and every married couple should have at least one of them in place before a death occurs, not after. The first and most common is a joint account with rights of survivorship. Under this structure, both spouses are listed as equal owners of the account. When one spouse dies, the surviving spouse automatically becomes the sole owner. There is no probate. There is no court order. There is no waiting period. The surviving spouse retains full and immediate access to every dollar in the account from the moment of death. The bank will need a death certificate to remove the deceased spouse's name from the account, but that is an administrative step. It does not restrict your access to the funds. Here's the critical detail most people miss. In several states, including Texas, the right of survivorship is not automatically applied to joint accounts. You must specifically request it when the account is opened or sign a separate survivorship agreement at the bank. Simply adding your spouse's name to the account does not guarantee survivorship rights. If the account is structured as a tenancy in common instead of a joint tenancy with survivorship, the deceased spouse's share becomes part of their estate and goes through probate. The title on the account controls everything. If you are not certain how your accounts are titled right now, you need to find out this week. The second structure is a payable on death designation. This is sometimes called a transfer on death or a Totten trust. It allows you to name a beneficiary directly on the account who will inherit the funds when you die. No probate, no court involvement, no attorney fees. The beneficiary presents a death certificate and valid identification to the bank, and the funds are released. Setting up a payable on death designation is free at virtually every bank in the country. It requires filling out a single form. The beneficiary has no access to the money while you are alive. You retain full control and can change the beneficiary at any time. And it works on checking accounts, savings accounts, money market accounts, and certificates of deposit. If you have any account in your name only and you have not added a payable on death beneficiary, that account will be frozen when you die, and your family will need a court order to access it. The third structure is a revocable living trust. A trust allows you to transfer ownership of the account to the trust while retaining full control during your lifetime. When you die, the successor trustee you named in the trust document takes over and distributes the funds according to your instructions. No probate, no freeze, no court. This option requires more setup than the first two, typically involving an estate planning attorney, but it provides the most comprehensive protection, especially for larger estates or couples with complex financial situations. There is one additional rule that surprises almost every surviving spouse. Power of attorney. Dies when the person dies. If your spouse gave you power of attorney over their accounts, that authority ends the instant they pass away. It does not survive death. It does not give you access to their account after the fact. A surviving spouse who walks into a bank with a power of attorney and a death certificate will be turned away. The only documents that grant post-death access are letters testamentary from a probate court, a joint account title with survivorship rights, or a payable on death designation. Nothing else. Here are your action steps. Execute them in order. Step 1. Go to your bank and ask to see the account title on every account you hold. Ask specifically whether each account includes rights of survivorship. If the answer is no, or if the representative is not certain, ask to add survivorship rights or convert the account to a joint account with survivorship on the spot. Step 2. For any account that is in one spouse's name only, add a payable on death beneficiary immediately. The form is free. It takes 5 minutes. And it is the difference between your surviving spouse having immediate access to funds and being locked out for months. Step 3. Check whether your spouse's Social Security direct deposit goes into an account titled in their name only. If it does, redirect it to a joint account. When a Social Security recipient dies, the SSA will reclaim any payment deposited after the date of death. If that payment lands in a frozen sole name account, the bank returns it to the government, and the surviving spouse cannot intervene. Step 4. Do not rely on a power of attorney to protect your spouse after your death. It will not work. Your bank does not care how long you were married. It does not care that you raised a family together. It does not care that the money was earned together. It cares how the account is titled. That is the only thing it sees. Fix the title now while you still can.